So I've just brought you a couple of legal stories that Glenn would probably cover, and we're praying that Glenn might just take the time off and rest and relax, rejuvenate, and enjoy time with his better three quarters. So where did I get to? We've got Sally Ann, Ruth, Marie, Gordon. Gordon did ask me. Yes. Glenn didn't ask me, but Gordon did. And that's all I needed. That's all I needed. So I think we've already been counted down. Welcome, Anne. Everybody come in quick. I know Glenn usually gives you longer to get sorted, but there's only a few of us, and we're just doing a place holding for Glenn so that he knows we care and we're still here and we're waiting for him and we miss him. But we're very, very glad to hear that he's at a Springsteen concert. That is freaking awesome. So hello to Anne and Tamara and Tracy and Karen and Elsie. And are we ready? Shall I do the 3, 2, 1 so Glenn can use it if he ever wants to? Can't imagine why he would, but let's give him the option. So 3, 2, 1. Did anybody watch that? It's Google it. 3, 2, 1 and Dusty Bin, Ted Rogers. Only British people of a certain age will know what I'm talking about. So, as we all know, Glenn is taking a few days off with the family. So today, it's me, friend of the program, taking over the chair, whether he wants me to or not. Because justice doesn't take a vacation. We know that. And today the courts are busy as they always are. So let's get into it. 2 stories, both decided in courtrooms today, both about the same fundamental question. Can a president use the machinery of government to punish people he doesn't like? Well, we know he can, but will he receive any kind of a pushback? What will the ultimate outcome be from him trying to do so? Let's find out. Is there going to be accountability? Well, let's see what the courts had to say today. So first of all, we've got a story that Glenn's been watching closely. This is about the law firms, the retribution meted out by the Trump administration, and it's in the DC Circuit Court of Appeals in Washington, DC. This goes to the heart of whether lawyers in the United States can represent clients the president dislikes without fearing that the full weight of the federal government is going to come crashing down on them. And we all know what the answer should be. It's what justice is based on. We all have the right to be presumed innocent until proven guilty. We all have the right to an adequate defense. And it's only storing up problems for the future if the administration are going to interfere with the administration of justice. Because the Constitution is very clear that everybody deserves a defense in court. And if law firms are going to be impeded because they're fearful of retribution from the government, then that part of our inalienable rights is not going to be able to be upheld. So, they're shooting themselves in the foot. But I don't suppose that anyone would accuse this present administration of being forward thinking, except when it comes to their own enrichment. But I digress. So the 4 firms in this case are Perkins Coie, Jenner and Block, Wilmer Hale, and Sussman Godfrey. The executive orders against them sought to revoke their employees' security clearances, bar their lawyers from entering federal buildings, and terminate government contracts held by their clients. 4 separate district court judges, including Republican appointees, looked at those orders and said, unconstitutional. Some of those judges used language you don't often see, describing the pressure campaign as reminiscent of McCarthyism. They were not pulling their punches. It is clear where those local court judges, the circuit court judges, stand on this. But we all know that's not where it's going to end. So today, the Trump administration went to the DC Circuit Court of Appeals to try and get those orders reinstated. And the panel they faced, 2 Democratic appointees and 1 Republican appointee. None of them were giving them an easy ride, which is good news for justice. Here's one of the government's core arguments. Well, this is basically the government's only argument. They say, this is what they maintain, a law firm's commercial associations, including the lawyers it employs, are not protected under the First Amendment free speech. They argued that revoking security clearances is squarely within presidential authority and that the lower courts had encroached on executive power over national security. That's the government argument. And that's where the panel pushed back hard, you will be pleased to know. See, little points of light. Judge Sri Srinivasan, I apologize if I've said it wrong, who's an Obama appointee, pressed the DOJ attorney on a critical point. Can the president revoke security clearance for reasons that have nothing to do with whether someone can actually be trusted to keep secrets? Because that's always been the legal basis for clearance decisions. So can he revoke them as punishment for representing clients the president doesn't like? That's a very different thing. And the DOJ did not have a very good answer. Shock horror, right? For the law firms, former Republican appointed Solicitor General Paul Clement argued that these orders strike at the heart of the First Amendment, and with my limited legal knowledge, I make him right. They strike at lawyers' fundamental ability to represent unpopular clients without fearing governmental retribution. It just can't be a thing. That's not a small point, and you will be relieved to hear that they were very firm in pushing back on this point. The rule of law depends on people being able to get legal representation, regardless of who they are or what they've done or who they've angered. And so far, the judges are pushing back. But the telling detail is this. The DOJ focused most of its argument time on this security clearance piece, because that's where they think that courts have traditionally given the most leniency to the executive. The fact they're leaning hardest on the narrowest possible argument tells you a lot about how confident they are on the broader constitutional picture. We can all see it ain't got no legs. This is not going anywhere good, but no ruling yet. These cases will go wherever the DC Circuit takes them, and from there, either side can appeal up to where, everybody? Oh, say it together. Yeah. So watch this space. And the next story, we hinted at it back in my show all those minutes ago. That's right, Gordon. Yeah, the Supreme Court will make the final decision, and who knows? Supreme Court. Yes, thank you, Laura, not Luma. You ready for the second story? And there are points of lights here as well, but you know, it's never one-way traffic, is it, with this administration? Trump versus Carroll at the Supreme Court. Gordon, I'm not going to say that out loud. I'm too much of a lady. So this was a Supreme Court private conference in Washington, D.C., And this was much quieter. It didn't make the front pages, but potentially it could be more consequential in the long run. Today was a Supreme Court private conference day, and on the docket was Trump's petition for the justices to take up the E. Jean Carroll case, specifically the $5 million verdict that a New York jury returned after finding Trump sexually abused Miss Carroll in 1996 and defamed her after she published her account of it. This petition has been rescheduled from private conference multiple times already since February of this year. Today was the latest scheduled opportunity for the justices to decide whether or not to take it up. As of the time of recording, there is no announced outcome, so we are watching, and Gordon, we will get to the other millions. Don't worry, I've done my homework. This is where the legal picture gets genuinely significant because as of now, there are two E. Jean Carroll judgments in play at the Supreme Court level. And of course, Gordon spoiled it for everybody by jumping ahead there. But Gordon is absolutely correct. So that's the $5 million one, which is about evidence rules and the admission of the Access Hollywood tape, whether that's allowed, and testimony from other accusers. So they've got to make a decision about, oh, Gordon, that's okay. I forgive you. You can come back anytime. But yes, then Gordon, the $83.3 million defamation judgment, because it's still accruing interest, that is where the situation has escalated considerably. You want to hear more? Of course you do. That's why you're here. On that larger judgment, the Second Circuit upheld it in April, and then in late April, they denied a rehearing by the full bench. I think that's the en banc thing, but I don't have the fancy schmancy terms that Glenn does. He can tidy all this up when he comes back. I'm just going to do the heavy lifting, and then he can rearrange the furniture in the room once we've unloaded the removal van. Yes, so because of that, and I think that's what the Trump administration wanted, if I remember correctly, that left the door open to a Supreme Court petition, and Trump's team filed for a stay, arguing that without one, Miss Carroll could move to collect on that judgment before the Supreme Court has had a chance to review it. Carroll's team agreed to the stay, but on the condition that Trump increases his bond by $7.46 million to cover the interest that could accrue through the period to October 2027. And that stay was granted. Now, here is the constitutional issue that is worth paying close attention. And as a constitutional guru, Glenn would want us to draw our attention to this. Trump's lawyers. This is not a shock. I read this earlier. I knew what I was going to say, but it hit me like a steam truck the first time I read it, and it's just hit me hard again. You're not going to like this, folks. So get your pillows to bite down on. Trump's lawyers are arguing that what should shield Trump from both the E. Jean Carroll judgments. What two-word travesty do we think Trump's lawyers are trying to use to get this thrown out? And if anybody else is frozen, let me know. I don't know how you'd let me know if you were frozen, but yeah. Oh, Lyra Jean gets the gold star. Gordon, you just, yeah, you're all on it. You're all on it. Yeah, exactly. I'm so sorry, but yes. The Supreme Court's 2024 ruling in Trump versus United States established broad immunity in what, ladies and gentlemen? Criminal cases. Trump's team, because that's not enough, because it never is, are now pushing for that protection to be extended to civil defamation claims arising from statements he made during his first term as president. I shit you not. Sorry, Glenn probably wouldn't say I shit you not, but you know. Think about what that would mean. A president could, in theory, and does, in my opinion, make false statements defaming somebody, ruining their reputation, and then claim immunity because he was acting in his or her official capacity. The Westfall Act argument goes even further. If the DOJ succeeds in substituting the United States government as the defendant in place of Trump personally, then the whole case collapses entirely because the federal government can't be, that's right, sued for defamation. The stakes here are enormous, ladies and gentlemen, and not just for Miss Carroll. If presidential immunity extends to civil defamation, the accountability gap for this presidency and every future one gets much wider, and it's going to make Glenn really, really, really cross. And none of us want that. We like happy Glenn. I hope he's rocking his little heart out tonight. So, the bigger picture. Two stories. One about whether the president can weaponize the instruments of government to punish lawyers for doing their jobs. One about whether a president can hide behind immunity doctrine to escape accountability for finding someone liable for sexual abuse. What connects them is this: the question of whether the rule of law applies equally to everyone. And it's a question that we really are scratching our heads over because it don't be looking like it do. Oh, Tamara, Tinternet. Tinternet is great. Tinternet and watching an awful lot more YouTube than I probably should and is good for me. And also going through checking to see if Glenn had posted anything. He didn't. This is all my own work. But, you know, I will defer to Glenn in matters of the law. He kind of probably edges me on experience, wisdom, good looks, all the things. So I will repeat, because it's never been more true now, and I'm sure if Glenn were here, he would say it. The law is not optional. Accountability is non-negotiable, and justice matters. I will post the research on this video, not behind a paywall, so that any of Glenn's groupies in the get-together can access it. They can see where the information has come from, because I'm not Glenn, you know? You don't know who I am. You don't know where I'm getting these. I could be picking these stories out my bottom for all you know, but I'm not. I'm really not. I promise, I promise, I promise. So anyway, that will all be uploaded for you. I will add the file so that the video will go up, and then I will add the file because I don't want to interrupt it, because you know me and tech. I'm like Glenn. I can't spell IT either. So, you know, I'm in good company. But that's all for today's mini version with me, Mama, of Justice Matters. Glenn will be back soon enough. We're trying to keep him away from his computer while he's on recuperation. But we all know he's not gonna. We all know we're gonna see him before he gets back. But in the meantime, stay engaged, stay informed, and as always, take good care of each other, because justice matters.